The introduction of the Fair Work Act was designed to increase the rights of employees. The so-called general protections in the Act have recently been clarified by a decision of the full bench of the Federal Court. To walk us through what this means, particularly what it means for employers, Joydeep Hor is the Managing Principal of workplace law firm People and Culture Strategies. Joydeep, thanks for coming in. It's quite an interesting case, but I suppose before we start, just explain for us the essence. What is a workplace right?
So one of the things that the Fair Work Act introduced was a series of so-called general protections. Australia's had discrimination laws for many years. This was the first time that they were taken to a quite significant and serious level in industrial legislation, where the Rudd/Gillard governments were saying an employer that seeks to punish or exact any kind of detriment towards an employee who has a workplace right, for example, a right to make a complaint to their employer, a right to file a workers' compensation claim, a right to take sick leave, a right to take holidays, any number of those things, is protected from any form of adverse treatment or adverse action from their employer as a result of having that right or exercising that right. And that applies in a number of different contexts, not just throughout the course of employment, but also there's a prohibition on employers terminating the employment of an employee for one of those reasons.
So how does it differ to the old, I mean, everyone knows about discrimination in the workplace. How does it sort of differ to that?
I think that the difficulty with discrimination claims has always been a difficulty that an employee would have in proving that a reason why something has happened to them in the course of employment was because of one of those attributes. What the Fair Work Act does, and this caused a lot of consternation for employers, was it said if such a claim is made, the onus is actually on the employer to disprove the allegation. So you as the employer have to positively show that why you did something was not because of a workplace right or one of these attributes. And it's quite a hard thing to do if there's 100 reasons why something might have happened, and one of them might have been something to do, or even perceived to be something to do with one of these workplace rights or one of these attributes. You're really hard-pressed to win your case as an employer. And so what we saw in this particular case was an employee who was a teacher at a TAFE institution, who was also wearing the hat of a union delegate, sends an email to all of the relevant union members at this particular organisation saying time for audit and accreditation is coming up. There's rumour that people are being pressured to sign off on fraudulent documents. Whatever you do, make sure you don't succumb to that kind of pressure. So this goes out by way of email. The employer finds out about it. The employer is a little bit annoyed about the inferences about the employer engaging in fraudulent conduct or whatever else. Takes a number of steps towards that employee in terms of suspension, not allowing internet access, a range of other things. The employee says, well, the only reason you're doing this is because of my union delegate status, and I have a workplace right to be a union delegate and engage in particular activities, so therefore I'm going to say that you have breached your obligations under the Fair Work Act, you've treated me adversely.
So what if that employee of that TAFE had not been a union member, if he'd just been a very run-of-the-mill employee? Would this case have still become a test case and he'd done the same actions?
Look, hard to say, because it doesn't immediately in those circumstances fall within the heading of the workplace right that was dealt with in this case, or that was challenged in this case, being the fact that he was a union delegate. But by the same token, non-union delegates will still have various workplace rights to make complaints or grievances within their own organisation, and they will still also have the protection of these general protection claims under the Fair Work Act. And what's interesting about the full court's decision, which has only come down in the last few days, is it says to employers that it doesn't matter what your motivation is or what you believe to be the reasons why you have done something. Objectively, the court, the law, will make its own assessment as to why something has happened. And if the view as to the real reason that something has happened is that it is because of one of these attributes or the existence of a workplace right, then that finding is probably going to go against the employer. So
there's a lot of, you used the word perception earlier, and there seems to be a lot of that in this set of laws. How do you, as an employer, how do you take disciplinary action against a staff member who, in your view, not for any reason of being a union or any other, one of the discriminatory issues that we might have had, just hasn't been doing their job properly? How do you take disciplinary action and safeguard against this?
Yeah, it is really, really difficult, and I think the Fair Work Act has introduced a whole new suite of challenges for employers. What those employers have to do is they have to not just be very clear as to what the actual reasons are and be pure, if I could put it that way, in terms of not allowing any taint of one of these protected rights coming into it, but also making sure that there's a paper trail that's created that makes it very clear that it has nothing to do with any of those attributes. There's no side conversations that are taking place, not just with the employee, but someone else who might be called to give evidence against the employer. So it's not just about doing the right thing, it's also just as much about being seen to be doing the right thing for employers. And with this whole reverse onus issue, where it does shift to the employer, it's really quite challenging.
The government, I think, the Fair Work body, they will give not support, but you can, if you're a business owner or an employer, actually call them and ask all those questions and have them help you. Yes.
Yeah, absolutely. Yeah. I mean, the institutions are there to provide that support, but if an employee brings a claim against you, there'll be limitations.
All right, Joydeep, thank you.
Thanks, Carly.
We have to take a short break. Stay with us though. Street Centre.